Mr. Chairman, Rick Jore, I'm from Ronan. I stand in opposition to Senate Bill 262, and hopefully I can maybe explain in more detail my perspective of why provisions of the UMO within the compact violate provisions in the Montana Constitution. If you have the bill, at least the copy I had on page 40 was the establishment of the Flathead Reservation Water Management Board, and details regarding the authority and jurisdiction and duties of that board are described in the next several pages if you want to look at that. The language is clear that the board does indeed have exclusive, that's the word, jurisdiction regarding the administration of water rights within the boundaries of the current Flathead Reservation. Understand, and I'm sure you've probably heard some of this, that the Reservation Water Management Board is made up of 5 voting members. 2 are appointed by the Tribal Council, 2 are appointed by the Governor, and then those 4 choose a 5th. My contention is that in that scenario, because my tribal member neighbors are also state citizens and have opportunity to vote for governor of the state, then they will have 2 votes to determine the makeup of the board. They'll have a vote for the governor and then, of course, a vote for the tribal council. Non-tribal members will have 1 because they have only a vote for the governor. So that is, in my view, a diminished representation there for tax-paying Montana citizens who own fee land or within the boundaries of the reservation. Understand, please, then, that in addition to being removed from the process of water rights administration used for all other non-tribal member citizens within the state, non-tribal member citizens, state citizens, living and owning fee land within the boundaries of the reservation will clearly have diminished representation in state government, if any representation at all. And so I think they could perhaps ultimately make a claim that they have taxation without representation, which, as you know, is a fundamental principle of our system of government. I won't read Chairman Tweeten's statements regarding the grand bargain because Ms. Vandermeer read those, but just to point out that the chairman of the Compact Commission has in fact recognized this fact that non-Indian rights will be removed from the protection of the state. Let me, some of the response that we have to that point is that ultimately we can appeal to the court in the compact, that will still give us state representation. I would point out that the language is that we can appeal to a court of competent jurisdiction, but the definition in the definition section of the compact, Article 2, of a court of competent jurisdiction is ultimately a court that has jurisdiction which the 2 parties agree to. And I would submit that typically in a dispute there or an appeal from a board decision between perhaps the tribe and a fee land owner or a fee land non-tribal member owner, and a tribal member would ultimately then end up in the federal court because in that definition the 2 parties have to agree to the court, otherwise it goes to the federal court. So my point being that in fact state citizens will have representation in their state government, including the courts, removed from them. In a letter of July 30th, 2015, I want to address a point that a state solicitor, Dale Schoengert, made in his contention that this compact does not violate equal protection because he said citizens have to be similarly situated, and he contends that non-tribal member state citizens are not similarly situated because of where they live in the state and that, quote, non-tribal citizens moving to the reservation should know that when they live within the boundaries of the reservation, they might be subject to different rules. I disagree with that, and that fundamental disagreement goes to how the compact defines the Flathead Indian Reservation. If you look again in Article 2 in the definitions, it clearly defines all land within the boundaries of the original definition as being in reservation status. And it says notwithstanding the issuance of patents and including all rights of way. So the conflict that comes to my mind is the fact that the state of Montana, on the one hand, is saying for tax purposes that this fee land is part of the state of Montana and is not in reservation status, but for purposes of water administration under this compact, fee land, such as my property, is in reservation status. So I view that as double-minded, and I would hope that perhaps you would take into consideration the language in Article 1 of the Montana Constitution that was Enabling Act language that was incorporated there that specifically says that all land owned or held by any Indian or Indian tribe shall remain under the absolute jurisdiction of the Congress. And so I guess I would say I don't believe the state can have it both ways. It's got to be one way or the other. Either fee land there within the boundaries is part of the state of Montana or it's not. So I would contend that non-tribal member state citizens who live and own property within the boundaries of the reservation are, in fact, similarly situated with those who reside outside the boundaries, because in both instances, they live in Montana as Montana citizens, and they and their property are subject to all applicable Montana laws and taxes. Therefore, the Montana Constitution should apply to them equally. And I would submit to you that Montana does not have to violate constitutional obligations of its government to all of its citizens to allow for the federal government to fulfill its fiduciary obligations to the tribe. I don't think it was necessary, and I don't think it was appropriate in this negotiation process for the state to create this water management board, which takes away representation of certain citizens. Finally, Mr. Chairman, I would simply say this regarding the amount of money that the state commits in this compact. I do not believe that the taxpayers of Montana are in arrears to the CSKT tribes and or the Flathead Irrigation Project irrigators, and I am opposed to the $55 million commitment in the compact. Thank you, sir.